Okay, good evening everyone. Welcome to this Planning Referrals Committee meeting. Before we start on the agenda, may I just take this opportunity to advise you that if the fire alarm does sound, please remain seated to enable me to assess the situation and give further instructions on the evacuation of the building if necessary. Tonight's proceedings will be webcast by the Council, but if anyone else is intending to record these proceedings, can you please let me know now? I ask this question not to stop you, but merely to ensure that members and other members of the public in the room know that this is taking place. Thank you, Ellen. Okay, I will move on to the first item on the agenda today. Apologies for absence. I've received apologies for absence from Councillor Brian Mortimer. And the second item on the agenda today is the notification of Sorry. That's absolutely fine. Okay. Thank you. Notification of substitute members. Are there any substitute members?
Councillor Derek Mortimer for Councillor Brian Mortimer.
Thank you. I've noted. I will now move on to the election of a chairman. Could I ask for nominations for chairman, please?
I'd like to propose Councillor Sams, please.
Is that seconded? Thank you. Is that agreed, members? Yeah. Would you like to come and take the chair, Councillor Sams?
Good evening, everyone. Okay. We normally have an election of a vice chair, but as we'll not be meeting again this municipal year, I don't intend to elect a vice chair. Can I ask whether that's agreed by members? Yep. Urgent updates. There should be an urgent update that everyone's had. Council members have had that? Yep. Notification of visiting members. I can see that there are quite a few visiting members. So can I ask who they all are? Thank you.
Councillor Prendergast, and I'll be speaking on this item. Thank you.
Councillor Garton, and I'd like to speak on this matter as well, please.
Thank you.
Councillor Perry, and I wish to speak on this item.
Councillor Gordon-Newton, I'll be speaking on this item. Thank you.
Thank you.
Councillor Bell-Springett, I'd like to speak on this item.
Councillor Spooner, and I would like to speak on the issue as well, please. Thank you.
Thank you, Councillor Spooner.
Councillor Mrs Stockel, just here to observe and listen.
Councillor Powell, just here to observe.
Thank you. Any other visiting members? Okay, agenda item 7, disclosures by members and officers. Are there any disclosures by members and officers? No, not lobbying, disclosures. Agenda item 8, disclosures of lobbying. Have any members of the committee been lobbied? Thank you. Item number 9, to consider whether any items should be taken in private because of possible disclosure of exempt information. We have an exempt appendix on the agenda today containing confidential legal advice, and if members wish to discuss this advice, I propose that we move to exclude the press and the public. Is that agreed? Okay. Agenda item 10 is the minutes held of the last meeting, which was back in May 2015. Are the minutes agreed as a correct record? They're on pages 1 and 3. Yep. And agenda item 14, are the part 2 minutes agreed as a correct record? Yep. And if the committee wishes to discuss part 2 minutes, obviously that would be something that we'd have to do at the end of the meeting, as set out in the agenda, and move to exclude the press and the public. Is that okay? Presentation of petitions. There are no petitions this evening, so we'll start with agenda item 12, which is question and answer session for the members of the public. Obviously, this is a very emotive issue, and if I can ask that while people are speaking, whoever they are, for everyone else to be quiet while they're listening, and we won't have clapping or jeering or anything else, please. And the question and answer session is limited to 30 minutes. So if people can be aware of that so that everybody gets time to speak. I've received notice that Mr John Horn would like to ask a question to the Chairman of the Planning and Referrals Committee. Mr Horn, could you approach the Speaker's table and press the button and ask your question, please?
Is this in contact? I've got it right, have I? I'm grateful to you, Chairman. Thank you. My question is this simply. As Woodcock Farm has been refused twice by your planning committee colleagues, do you not perhaps feel a little let down that officers do not feel inclined to defend the position, despite the inadequate drafting of the grounds for refusal?
Thank you, Councillor Horn. I suppose the answer is that the officers have given professional advice to the Planning Committee, both with respect to the original consideration of the proposals for Woodcock Farm and subsequently with respect to the appeal. So the reason for refusal was based upon the discussion and grounds put forward by members at the original Planning Committee meeting. In addition to that, officers have ensured that the position concerning the reasons for refusal agreed by the Planning Committee have been properly reviewed, given the change in circumstance arising from the local plan examination. So this is seen as good practice. Officers are continuing to give their professional advice to councillors at this committee, and consideration of the matter at the Planning and Referrals Committee is in line with the Council's agreed constitutional procedure on such matters.
Chairman,
Would you like to ask?
Yes, I would. I'm very grateful. Thank you.
You might.
Getting the technology right here. If your decision of the committee is that the decision of the Planning Committee should stand, we will then mandate officers that they should strongly defend the appeal in accordance with their professional ethos, recognising that the cost of this, in extreme circumstances, is less than 0.5% of the new homes bonus.
Okay, thank you. The matter about the costs on the 5%, can the officers answer? Sorry, but yes, 0.5 of the housing. You did say the new homes.
Indeed, yes, and it's extreme costs.
Okay. Yes. Okay. Yeah. Yes, sorry, Councillor Horn. Yes, you're right on the cost that's 0.5, and yes, the committee. If this committee vote for the council to defend the appeal, then yes, we would expect the officers to be there and to be given as robust defence as they can. Thank you. Thank you. Thank you. Can I ask Mr. Gary Thomas to give his question?
The question that I have and would like to ask you is that the planning inspector has not yet issued his final report on NBC's draft local plan. Will it be reasonable for your committee to be asked to assume that Woodcock Farm is firmly in the local plan?
Thank you for your question. We are considering the position in the full context of the stage that the local plan has reached at the moment. Decisions that the Council and the Strategic Planning, Sustainability and Transport Committee have made and the outcomes from the local plan examination. The new local plan is at an advanced stage. The Council prepared a comprehensive evidence base to underpin that plan, including an objective assessment of the amount and type of new employment land that will be required up to 2031. The Woodcock Farm allocation has been considered and agreed by full Council. It is by far the largest B-class employment allocation in the plan. It will address the evidence needs for a strategically well-located employment site in the borough, and it's also consistent with the Council's economic development strategy, which was agreed again by full Council. The local plan's approach to employment land, including the allocation of Woodcock Farm, was discussed at length and in detail during the local plan hearings, which, as you know, were very detailed and very long. Following this full debate, as outlined in paragraph 5.16 of the main report, the advice from officers is that the inspector has endorsed the general principle of Woodcock Farm employment allocation because it is necessary to meet identified needs for employment development in the period 2031. Would you like to ask a supplementary question, Mr. Thomas?
I'd like to just raise the point that you made. The inspector, in fact, has not validated the inclusion of Woodcock Farm. What he has said was, first of all, he wanted a much wider look at the employment in the area with the adjoining districts, which is, in fact, a requirement of the MPPF. That was not done.
Can I just interrupt? The supplemental question.
The supplemental question is do you know this situation, that it's the fact the Council did not follow the MPPF in looking at the wider area of the districts as required now by the inspector?
Yes, in answer to your question, I think that what the officers have done is that it has been done correctly. The need for employment has been looked at throughout, and they have followed the MPPF.
But just following that up, if I might, in terms of...
Is this another question?
Yes.
Yes, I'm sorry, you can only ask one supplementary question.
Oh, this is a lovely rule. Yes, only one question.
You've answered, no, you said one question and one supplementary.
And that's it. Thank you.
That Mrs. Cheryl Taylor-Maggio would like to ask a question of the Chairman of the Planning and Referrals Committee. Mrs Taylor-Maggio, could you approach the Speaker's table? Thank you. I know you're quite... you know
am
what
I on?
to do.
Right. Given the defined NBC constitutional procedure, is your committee comfortable with being invoked on this matter at this time?
Thank you for your question. This committee was set up specifically to deal with planning decisions which may have significant cost implications to the Council. It's appropriate for the Planning Committee to consider the impact on this case of the changed circumstances following the local plan inspector's report and the implication of costs at appeal. It was also appropriate to refer the decision of the Planning Committee to the Planning Referrals Committee for further consideration, and this is allowed under the Constitution. Would you like to ask a supplementary question?
Yes, if I may. Given the more than £15 million that NBC will have in the bank from the new homes bonus by the end of the year, and recognising that the apparently inadequately drafted grounds for refusal were in fact drafted by professional officers, do you think it is reasonable that NBC should spend £340,000 to £450,000 to defend the Planning Committee's 30th of June 16 decision that in effect they confirmed on the 27th of April this year and by a larger majority? Well, I asked them if they were comfortable. But the
I think your original question is on the constitutional procedure, which your supplementary is not.
So it's on how you feel about being asked, which is what I was asking. But
thank you. I've received notice that Mr. Peter Cooling would like to ask a question to the Chairman of the Planning Referrals Committee. Mr. Cooling, can you approach the table?
Thank you very much. As this is such a contentious strategic matter, do you think it is right that you should be asked to put costs above the decision of the Planning Committee? Thank you.
Thank you for your question, Mr. Cooling. The cost regime is an integral part of the planning appeals system, and if any of the parties fail to fully substantiate the case, then it will be open to award of costs, as you probably realise. The Council has an obligation to consider both whether it can substantiate its case and whether it is at risk of costs. Therefore, officers are simply advising on the cost risk due to the change in the circumstances since the decision, so members can make an informed decision. These costs can be very substantial in a complex case such as this, where it will be dealt with at public inquiry lasting 2 to 3 weeks, with large numbers of expert witnesses and barristers representing each party. The Council does have an obligation to consider both whether it can substantiate its case and whether it is at risk of cost. But we're not just looking at cost, but it is an integral part. Would you like to ask a supplementary?
I would, and no doubt I'll be kept honest on its relationship to the original question. As the potential costs are trivial, 0.5%, in relation to the new homes bonus that will be accrued this year. Do you not think that the Planning Committee has already fully considered the merits of defending the appeal?
He's asking about the planning committee. Whether they've... That's the expenditure. The expenditure point is what he's asking about. 0.5%. Have we, or are we allocating? In response, simply said that as Sam's pointed out, that funding has been allocated to a capital programme, and that if we had a cost order against us, then there would have to be a re-looking of the funding. Okay. Yes. Yeah. Okay. Okay. What I'll do to answer that question is ask William Cornell to give you some help on that one, please.
Even though it was asked of yourself?
Yes, because he has the information that you need to hear.
Okay, thank you, Madam Chairman. Just to say, the new homes bonus is fully committed to our capital programme, which has been signed off by the Policy and Resources Committee. But that may be a piece of relevant information.
Sorry, Your Honour. As a matter of fact, the new homes bonus is not ring-fenced. If the borough has decided to put the new homes bonus to date ring-fenced into capital account, there's nothing to stop it putting into the revenue account, the RevEx account, the new homes bonus from the next 70 to 90 houses. So I'm very, very sorry. That is the sort of briefing, no disrespect, well, it is disrespect, that together with the officer's report that you've received, we would fundamentally contest the officer's report and fundamentally contest that.
Thank you very much. Okay, we move on to agenda item 13. And before we can begin to consider this item, can I remind members that the confidential legal advice that was sent out separate to the agenda must remain confidential. If you wish to discuss the information contained in the yellow pages, we must move to exclude the press and the public from the meeting. And before the item begins, we're going to allow the public and visitors members to speak on the item. So the public will speak first, and the public have 3 minutes each. Then we'll move to the officers' reports, and then we'll move to the visiting members. So we have a list of them. Yeah. So can I call Councillor Mrs Taylor-Maggio, speaking on behalf of CALC. And you have 3 minutes.
Good evening. I am Vice Chairman of Maidstone CALC and part of the coordinating team that also includes the Joint Parishes Group, Maidstone CPRE, the Bearsted and Thurnham Society and Leeds Castle. We are very sorry that your committee has been called upon to accept officers' recommendations that would, in effect, overturn the decisions of your planning committee colleagues. They originally refused Woodcock Farm on the 30th of June 2016. Reasons for refusal were drafted by officers and no mention was made that the grounds for refusal might be unsustainable and costs were not raised as a crucial concern. In effect, the Planning Committee confirmed its refusal on the 27th of April this year and by an enhanced majority. MBC's constitution lays out a very clear and detailed procedural path should the head of planning wish to use your committee to challenge and overturn a planning committee decision. Crucial steps in that required procedure were omitted, and in addition, almost a year has elapsed since officers could have correctly triggered the procedure. We therefore believe that reference to your committee is not permitted by the Constitution and may therefore be open to serious challenge. Your committee should never have been put in this position, let alone receive an urgent update with which we fundamentally disagree. It is our view that your committee is being misused by officers who are reluctant to defend the appeal, if not desperate to avoid defending it. Part of that reluctance derives from their view that their original drafting of the grounds for refusal is deficient. Well, that means they have just made their job a lot harder. Reluctance may also derive from the claim that this site is in the local plan, but that is not settled. The Inspector has raised substantial questions about employment across the wider economic area. That includes 5 neighbouring authorities. Whether this site survives the local plan main modifications process remains to be seen. It is premature to assume it. You may wish to consider declaring that your committee should not have been invoked and then end this meeting, or recognising that this site is not an assured element of the local plan, you may consider deferring this matter until the local plan is finalised, or even conclude that this site should be dealt with as part of the first review to be completed in April 2021. To repeat, we are very sorry that you have been put in this position. Thank you.
Thank you very much. Can I call Councillor Horn, please, on behalf of the Joint Parishes Group?
Right, we have contact, I think. Good evening, Chairman. In a planning appeal, costs do not follow the event. They are not awarded simply because an appeal is allowed or dismissed, and the Inspector may disagree with the evidence put forward by a party. They are only awarded by an Inspector if one of the major parties behaves unreasonably. And here, in the present case, we have a strong case to put forward upon the existing reasons for refusal, a view which is shared by KCC, who are a Rule 6 party to this appeal. There are further reasonable grounds for refusal, based, amongst other things, on the uncertainties of the evolving draft local plan, on the additional studies required by the Inspector before there can be any allocation of Woodcock Farm as an employment site, and again, the additional studies were across the wider economic area, including the 5 neighbouring authorities. In the event, the case is not proven. There is nothing unreasonable, Chairman, for Maidstone Council to reconsider aspects of the draft local plan in the light of the Inspector's final report. Again, in the light of other studies which have now come to the fore. And again, in the light of public opinion, while the plan is still in draft form, which it still is, Chairman. The evolving and uncertain nature of the draft local plan is itself a material consideration. It should be used to defend the appeal. A well-argued case based on these matters is not unreasonable and should not incur the sanction of adverse costs, and I underline that phrase. The officer's stated reasons for recommendation, I'm afraid, are unsafe or unsatisfactory. And I would simply ask you, Chairman, to defer the matter sine die. Thank you.
Thank you, Councillor Horn. Can I next ask Mr Vidler from Bearsted and Thurnham Society? Thank you.
Thank you very much, Chair. I've just got 3 points. First, the nature of the employment debate for the local plan changed fundamentally with the inspector's request that job needs and employment land availability should not be confined to the MBC administrative district, but be assessed across the wider economic area, including Tunbridge and Malling, Ashford, Swale, Midway and Tunbridge Wells. The report MBC commissioned in response to the inspector's request was set out in document ED 118. From this report, it is by no means clear that there is an immediate demand for employment that cannot be met elsewhere within the borough or by cooperation with the neighbouring authorities already referred to. Secondly, it is widely accepted that there has been and is little demand for office space, hence the decision to allow the next development at Eclipse Park and support for the Waitrose application at Junction 7. In terms of other types of development, and based on the borough's own figures, Woodcock Farm offers over 46,000 square metres of possible development, but other sites provide over 500,000 square metres of potentially developable land, more than 11 times as much. It is our contention, Chair, that these figures demonstrate that there is no need to rush through a decision on Woodcock Farm, or indeed to designate it at this time as a critical site for employment needs. The review of the local plan, due to be completed in 2021, allows for a more considered decision on employment needs and locations to be made against developments in neighbouring authorities, especially Tunbridge and Malling, and a more detailed assessment of outward commuting patterns, particularly those to London, as well as to establish sites between Aylesford and Larkfield. What happened at Junction 7 is a salutary lesson. This too was once the great white hope for high-quality, well-paid jobs in Maidstone. Against its stated objectives, it has not been a success. It is important that the same mistakes are not made again. We contend that it is in the long-term interest of the people of Maidstone that these matters receive the fullest possible evaluation, and that such an evaluation cannot be completed on the timescale that has been set out in the briefing laid before the committee this evening. Finally, no one can be sure of the outcome of the inspector's recommendation and deliberations. The key point is that nobody knows what the inspector is going to decide. That being the case, it would be profoundly wrong and undemocratic to prejudge the outcome of the main modification examinations until the inspector has opined. For all these reasons, Chair, we respectfully ask that the committee stands by the decision of the Planning Committee and does not overturn them. Thank you very much.
Thank you, Mr Vidler. Can I ask Mr Thomas from CPRE, please? Thank you.
Thank you, Madam Chairman. I'm Chairman of Maidstone CPRE and I'm Parish Council Chairman. We are completely mystified by the presence of this site in the draft local plan because it ticks every box for refusal. There can be no doubt that the location of Woodcock Farm forms the setting of the AONB. In numerous paragraphs, the draft local plan protects the setting of the AONB. Also, this site is contrary to at least 9 separate paragraphs of the MPPF, all of which have been ignored. The report also states that both Kig and the Waterside Park inquiries were not considered to be relevant, but they were both refused largely on environmental grounds. And Woodcock Farm is directly adjacent to the AONB, unlike Waterside Park, which is the other side of the A20. Were Woodcock Farm to be approved, it would undermine the reasons for refusing Waterside Park, which would very likely come forward again, probably leading to us losing the rural gateway to the town and the rural approach to Leeds Castle. There was a huge number of objections to the site in the Regulation 18 consultation, including KCC, all local parish councils, the Joint Parishes Group, Maidstone Calp, local organisations, including the Bearsted and Thurnham Society, CPRE, the AONB Management Unit, both of our local members of Parliament, and very many local people, and especially Leeds Council. All were ignored, and the site was left in the draft local plan as sent to the Secretary of State for examination. However, the local plan inspector, in his interim report, questions its inclusion. You've heard already about the requirement to have much wider view, but it also suggested that consideration, I quote, consideration should be given to safeguarding part of Woodcock Farm or other sites for office development. It is not a proper endorsement of the site in the plan. The site is one of the worst in the borough for providing employment for Maidstone people, due to its ease of access for other districts. The only reason for an employer to locate an office at a motorway junction is to have the widest possible area from which to recruit staff. There is no other reason. Perhaps only 30 to 35 jobs would be taken by the borough's residents. It would draw employees from a much wider economic area, which is why the wider area must be the basis for analysis. Approval of this site would set a very worrying precedent in a very sensitive part of our borough, and we ask that you support the decision of the Planning Committee and not overturn it. We're very concerned at the action of Maidstone planners and their promotion of this site, and we ask why. Thank you.
Thank you very much, Mr. Thomas. Can I ask now for the Parish Council representative, Councillor Bennett from Hollingbourne Parish Council.
Are we alive? Well, here we go again. I'm quite amazed following the clear words of Councillor Mrs Taylor-Maggio about the constitutional matter that you didn't actually stop the meeting, because you should have done, in my not terribly humble opinion. Ever since the start of this application, there has been what has verged on an evangelical zeal by the officers in trying to get it through. In fact, so much so, and I'm sure he will correct me if I'm wrong, that the chairman of planning had to remind one of the senior officers that he was not an elected member, he was a servant of the council. That didn't bode terribly well for a fair-minded approach to this matter. When I got involved with the planning at Hollingbourne Parish Council, I fondly imagined that dealing with the officers would mean that we would have a fair hearing and they would treat us with the same respect as they did the developers. Silly me. We've had a consecutive amount of applications in our borough and indeed in our parish where the developers have been, shall we say, given every courtesy and we have been treated like a bunch of country bumpkins. As one of our members is a former Commander-in-Chief of the local army and an MBE, I don't think he's a country bumpkin somehow. We come down to the question that was asked right at the end of the previous speaker. Why do we have this problem with the officers defending or not the situation regarding this application? Cost? Well, we don't really know, do we? We don't know till we try, as they say, and I think that the failure is not so much not defending something, the failure is not to try and do your very best. Sometimes your bosses make decisions you think are daft, but the reason is that you put up with them is that they're the boss. I didn't vote for the winning candidate in last week's county council election. I do beg your pardon. But I still abide by the result, as indeed officers should. As I pointed out last week, the job centre's not all that far away. There's an air of tired desperation about the officers. They don't fear the cost. They fear they might not get this through.
Thank you, Councillor Bennett. We'll move now to the officers and then the visiting members can speak.
Thank you, Chair. Good evening, members. I'll just go through a brief presentation of a summary of the report. So as we know, this application relates to the, this item relates to the outline application at Woodcock Farm that was refused by the Council last July and the subsequent appeal that has now been lodged. The outline application was for a mixed commercial development of offices, light industry and warehousing with a maximum floor space up to roughly 46,000 square metres. Apart from the access to the site, all other matters were reserved for future consideration, and as such, the Council was only considering the principle of up to that amount of development and the type of development, and only the specific details of the access to the site. So the Council was not considering the layout, how the buildings looked, specific heights. Those details would come at a later date through a subsequent application. The main report outlines that the appeal has been lodged and it's usual practice for the Council to review its reasons for refusal and any material changes in circumstances. The report outlines how officers have reviewed the situation, taken legal advice and made 4 recommendations to Planning Committee on the 27th of April. The first recommendation is considered to be the key issue, and this seeks agreement that the reason for refusing the application is not defended at appeal. As we know, the Planning Committee voted against that recommendation, and in line with the Council's constitution, the matter has come before the Planning Referrals Committee. Recommendation 1, which is before members tonight, the report outlines why officers consider the grounds for refusing the application can no longer be sustained, and thus to continue with those grounds would be unreasonable and would expose the Council to a very high risk of an adverse and substantial cost award, in addition to the Council's own costs of defending the appeal. And I'll summarise why, essentially, officers feel that. So the Planning Committee made an in-principle objection to employment floor space at Woodcock Farm under the planning application last year. This was fundamentally contrary to the draft policy at the site, which allocates Woodcock Farm in principle for employment floor space. Now, the reason for this allocation is the evidence base of employment need within the local plan and the need for a new employment site at a location with good strategic road access to markets, i.e. by the M20 motorway. The Council took a democratic decision to submit its local plan and provide for all of this employment floor space within the borough, including the allocation at Woodcock Farm, which was by far the greatest allocation. If the Council decided it was not going to meet its needs at Woodcock Farm, it would have had to have found another site to accommodate the need in the borough or secured a formal agreement with a neighbouring authority to take the need, which it did not. Following refusal of the application, the Council did not remove Woodcock Farm from the local plan and defended it during the local plan examination. In the Inspector's interim findings report, it's considered the Inspector endorsed the general principle of the allocation, finding it necessary to meet identified need for employment development subject to modifications. He makes no comment that the site should be removed, as he has done for other housing sites in the local plan. And he actually states that in the absence of alternative provision beyond Woodcock Farm and other allocations, that there's likely to be a shortfall in office floor space in the borough over the planned period. The Council submitted its response to the interim findings, including a requirement of 10,000 square metres of office floor space, safeguarded until 2026. The Council then provided further endorsement of the allocation policy in agreeing that these main modifications at the SPS&T Committee in March 2017 to be consulted upon. The consultation is on the modifications, not on the principle of an allocation at the site. Recommendation 3 tonight, as I said, the key issue is recommendation 1. Recommendation 3 is a situation because the policy has changed since the application was determined through the examination. The appeal proposal no longer complies with the modified policy. Now, the applicant has, however, outlined that they intend to comply with the amended policy through potential amendments to the appeal. They would need to formally submit that. In the event that the appellant doesn't submit amendments or the inspector doesn't allow them, it's considered reasonable for the council to object because the proposals won't accord with the modified policy. However, this recommendation is dependent on recommendation 1. If members decide to stick with the grounds to defend the appeal, then this recommendation falls away. Just lastly, and this should have no bearing on members' decision this evening, but for information purposes, a new outline application for up to 45,000 square metres has been submitted by the appellant on the 2nd of May. The applicant submits it substantially compliant with the emerging policy for the site, which on inspection seems to be the case on an initial review. However, that application will obviously be thoroughly assessed, including careful consideration of all representations. Importantly, the appeal has not been withdrawn. Thank you.
Thank you, Mr Timms. Is there other officers' reports? Or is, yep, okay, thank you. Right, if we move to visiting members, I've got a list, so if we go through the order that I've got the list, if you're happy with that. Yep, so Councillor Perry, would you like to speak? And if I can just remind you that obviously we don't all want to be here at midnight. So if everyone can, if members can also try not to repeat each other and stick to the points. Thank you very much. Councillor.
Madam Chairman, members, I'm sure you will have been bombarded with papers covering possible cost implications, including Learned Counsel's opinion, which I would emphasise is just an opinion, and in my personal experience, these do not always come true. But I'm not going to talk about these because, in my view, this is not the issue. It is about a key principle as to who is ultimately responsible for this decision. The Woodcock Farm application has been the subject of 2 full meetings of the Planning Committee. On the first occasion, it refused this application. On the second occasion, it was required to decide whether to continue to defend. Members of the committee were made fully aware of all the possible cost implications, but by an increased majority, which was cross-party, decided to continue to defend. The Planning Committee is one of the key statutory committees of this Council. It has 13 members, and they came to a democratic decision. I accept that the decision was not unanimous, but this is how our democracy actually works. I recognise that under our Constitution, as currently drafted, the Planning Committee's decision can be referred to this committee. But I'm struggling to see the justification for this action, given that the Planning Committee had been fully briefed on all the possible financial implications. The Planning Committee took this into account before making its decision, and in my view, this referral cannot be justified on this basis. Nevertheless, we are where we are, and as a result, I'm going to ask you to look at this from the position of members. Just as juries started to do 200 years ago, when one could still be hung for stealing a sheep, they defied the law by bringing in verdicts of not guilty. I'm in effect asking you to do the same. If a democratic decision made by the Planning Committee comprising of elected members can just be overturned, then it calls into question the whole process and the role of this committee and its elected members. Why have a Planning Committee at all? I implore you to uphold the democratically taken decision of the Planning Committee. I believe there's a major issue of principle at stake, which far outweighs issues of cost. This Planning Referrals Committee may be in the Council's constitution, but whether it's constitutional in democratic terms is, in my view, very, very questionable. Thank you, Madam Chairman. Thank you, members.
Thank you, Councillor Perry. Councillor Garton, would you like to go next?
Madam Chairman, members, as the ward councillor, I find myself in a very strange position here. I try to make sense here on behalf of my residents who entrusted me with their representation. And I must stress that not all my electorate are entirely opposed to this development at Woodcock Farm. I do not have a mandate to oppose any development outright, but I have the duty to represent my voters to make sure that if a development is pursued, it is the right one. Besides being a ward member, I'm also a member of the English Legal Bar. So I find it highly suspicious and personally offensive when officers were reluctant for me or my colleagues to see the barrister's opinion upon which they proposed to drop the defence of this appeal. At a meeting just over 3 weeks ago, we were told that the publicly available officer's report should suffice for us to see. Stories about secretive circulated yellow papers made the rounds over the last couple of weeks. It was almost like a James Bond movie, if you follow my email inbox. And now I find myself in front of an albeit constitutional 3-member panel who's asked to overturn a democratically debated, informed decision of a 13-member panel. Policy EMP 1.5 gives strong reasons to defend the current application if adverse landscape impacts of the submitted proposal outweigh the benefit of the qualitative and quantitative supply of high-quality business space. This is what the local plan seeks to achieve, and it was acknowledged by Mr. Meller in his interim report. If we do not defend, we would set a dangerous precedent which may open the floodgates to many more appeals across Maidstone. We would portray MBC as a soft target who gives in at the mere mention of the word legal fees. I was the first person to ask the officers for some indicative figures, how much the legal fees may be, but no figures were provided. I find that very strange, as the legal cost argument seems to be the driving force in this topic, that no costs can be estimated. Members of this committee, it is your right and your duty to defend this appeal, if for nothing else but to uphold the will of your and our electorate. Thank you.
Thank you, Councillor Garton. Councillor Prendergast.
Chairman, members. There has been much debate amongst residents of this borough and elected members since the Planning Committee met on the 27th of April and decided democratically by 8 votes to 5 to defend their decision of 30th of June last year. That is, to refuse planning permission at Woodcock Farm. I have heard much talk about whether the process is correct, whether members of this committee have had adequate planning training, and so forth. I'm not going to venture into that territory. You're all experienced members of this council and will be fully apprised of all the relevant planning considerations. What I want to focus on is our duty to the residents of this borough, what we have all been elected to do, which is lead the way in governance and decision-making. As elected members, we are charged with the governance of this council and are accountable for the decisions that we make. Our decisions are open to scrutiny by all, especially by those who have elected us. And judicially, they are challengeable. We need to be able to explain why we did what we did. These types of challenges, in my mind, can be overcome by sticking to a few basic principles. 1, did we engage in due consultation and take advice from our officers? 2, did we demonstrate a presumption in favour of openness? 3, did we demonstrate the clarity of our aims and the desired outcomes? 4, did we offer explanations of the options considered? And did we give reasons for making those decisions? I'm sure our learned friend over there will know exactly what I'm saying with those words. As a member of the Planning Committee, I can say with all honesty that these principles were closely followed on the 27th of April, when we arrived at the decision that we did, a democratic decision. We now find that our position is undermined by a constitution that prevents us from our role as strategic decision makers and leads to the question, Where will this end if the decision is not the desired one? Will another committee be formed, then another, until we come to a decision that suits? Will there be any point in having any committee make any decision whatsoever? Currently, it appears to me and many of my fellow elected members that the only committee that might be worth sitting on is a democracy committee to try and bring some change to this current situation. I am reminded of something that Thomas Jefferson once said: "I have no ambition to govern. It is a painful and thankless task." I have never really given much credence to this before and have never believed it is a thankless task. I am asking you tonight, members, please do not make me change my mind. Thank you.
Thank you, Councillor Prendergast. Can I ask that Councillor Springett comes forward?
Thank you. As I said before, I'm speaking on behalf of Councillor Cumming and Councillor Dwingdene. The Planning Committee refused this application last year in view of the harm it would cause to the landscape in this area. The countryside hasn't changed, and the sensitivity of the landscape has been evaluated and confirmed by the decisions of the 2 KIG inspectors and the Waterside Park inspector, plus a High Court judge. However, what has changed, or rather moved, are the goalposts. Yet we are told we are not allowed to amend the reasons for refusal to reflect changing policy. The opportunity will surely present itself during the appeal hearing to highlight which parts of the emerging policy apply, but if MBC doesn't defend it, it is effectively silenced. The applicant can use selective bits of the policy to support the appeal, but the council will not be able to highlight the bits the applicant chooses to ignore. They will have a free rein to present a one-sided case for this development. The landscape hasn't changed, just the version of policy in place to protect it. So our objection to this proposal should be defended. Not defending the appeal allows the applicant to design what goes on this land, but it should be us, the members, who decide what is or is not appropriate. The Planning Committee made it clear last year that this is not the right proposal. I get the financial argument, but that should not be the justification to not defend a decision made by members. The cost-saving argument could have been used against not defending the New Line Learning Site or Fant Farm. You can make the financial argument for virtually any appeal. They all cost money. But both Woodcock Farm and Fant Farms are sensitive sites, and local residents want them protected for their intrinsic beauty. What message are we sending out? Fight us to the bitter end and we'll give up to save money. It is our borough, and we should decide how it develops. It is a principle of the democratic process that elected members of the Planning Committee determine applications. Maidstone Borough Council must stand firm and rigorously uphold the correct decision the Planning Committee made last year. Not defending the appeal to save money is not the way to go. The refusal last year was the right decision and it should be defended. I ask you, therefore, members, to reject recommendation 1 before you. Now, this afternoon I've learnt that and we've been informed tonight, that a new application has been submitted. I've had a quick look at that. It's an outline application, but it's absolutely clear from the outline plans that the applicant just doesn't get Maidstone's aspirations for this site. The aspirations within the local plan and the amendments just being consulted on are looking for a prestigious development in a parkland setting. You look at the new plans, I don't think they could have crammed any more buildings into it if they'd tried. They just need to go away and rethink. And I've just got one comment, and this is a personal comment, and it's not a comment from Mike Cumming or Nick de Wiggendine because I haven't asked their permission. But those who supported the inclusion of Woodcock Farm in the local plan got us into this mess. And I hope they'll be proud of their work. Thank you.
Thank you, Councillor Springett. Councillor Spooner.
I feel strongly that Maidstone Borough Council must defend its decision to refuse planning permission for Woodcock Farm in order to respect the democratic wishes of the Planning Committee and the strongly held overwhelming objections of all the local, county, borough and parish councillors, as well as, of course, the massive local opposition of local people, as well as those at Leeds Castle. The appeal is defendable with quite reasonable planning reasons. What has changed since last June is the evolving planning policy context within which the material planning considerations in defending the appeal have to be addressed. The open landscape, attractive countryside, heritage assets and environmental features around Junction 8 have not changed, nor has public opposition to development at Junction 8. These important planning considerations were absolutely fundamental to the Borough Council's and the Government's decisions to reject KIG, to the Borough Council's and the Inspector's decisions to reject Waterside Park, and to the High Court's decision to uphold the Inspector's decision on Waterside Park, and of course to the Borough Council's decision in June of last year to reject Woodcock Farm. They were all successful then, and they can be successful again. The policies of the Maidstone Borough the Maidstone Borough-wide Local Plan 2000 are still relevant until replaced by the evolving policies of the new draft local plan. But the final report of the Local Planning Inspector has yet to be received, and it may identify further studies that need to be undertaken. The draft local plan does not contain such strong policy to protect the countryside around Junction 8, and it does, of course, contain policy EMP 15, identifying Woodcock Farm as an employment site. But the local planning inspector is somewhat ambivalent about Woodcock Farm as an employment site, and he has indicated that further studies need to be undertaken into the requirement for employment land which embrace the wider economic area, including the surrounding districts of Tunbridge and Malling, Ashford, Medway, Swale, etc. And this is a game changer. Within that wider area, there are other potential employment sites that need to be considered. The Inspector's proposed modifications are still out to public consultation, and this does not finish until the 19th of May. It seems to me that the Borough Council needs to reassess the draft local plan in the light of the local plan's preliminary findings and retain Woodcock Farm as a potential long-term employment site pending the outcome of further employment land studies with the adjoining district councils. It therefore also seems to me that the Borough Council should defend the appeal for the following reasons. Firstly, the long-standing and compelling landscape and environmental objection to development at Junction 8. And secondly, because in the light of the local planning inspector's findings, it is not yet satisfied that a case has yet to be made out for the release of this highly sensitive and controversial site for employment use. It seems to me that this is a pragmatic and prudent way forward based upon sound and compelling planning reasons. It will enable the Borough Council to defend the appeal, and if such a reasonable case is put forward, the potential liability to costs should not arise. If, however, it is decided tonight not to defend this appeal, it will in one fell swoop sweep away the previous objections to KIG and Waterside Park and everything else around Junction 8 and open up the floodgates for yet more industrial development, perhaps all the way from Leeds Castle to Bearsted. I urge you as strongly as I can, please, to defend the appeal. Thank you very much for listening.
Thank you, Councillor Spooner. Councillor Cumming. He's not here, is he? No. Councillor Newton, then. Thank you.
Thank you, members. One thing we mustn't lose sight of is the local plan, borough-wide local plan 2000. When the decision was made to refuse this application, it was based on sound planning decisions, ENV 21, ENV 28 and ENV 32, that protect the environment. Now, under no circumstances have they been superseded by any draft local plan. Hasn't happened. I sit here and I listen to them saying great weight will be given to it, but great weight hasn't been given to it. This decision was taken by the planning committee, fairly elected by the public of Maidstone, on the date of 30th of June 2016, 10 months ago, when this application, and those policies are still extant. They are still to be used, and the planning department still use them. I've evidence of that. So they have not been kicked out, weight added to them because of the draft local plan. I'm going to ask members, please look at the area and refuse this application. And I believe, actually, there is no robust financial evidence, and I'm going to repeat evidence, that has ever been provided to members, financial evidence, about what this application would bring to the Borough of Maidstone. There isn't any. It's never been shared with members anyway. And officers have failed to provide this basic information in their report to demonstrate the benefit that may have been given if you pass this. And I believe personally that members have been less than economical with the matters when providing weak details to defend the Woodcock Farm application. I'm going to use two words now. It's deceitful manipulation. Thank you.
Thank you, Councillor Newton. Mr. John, would you like to answer a few of those points? Thank you. Councillor Stockel, do you wish to speak? Thank you.
Thank you, Madam Chair. Just to go back in time, as part of the genesis of this emerging local plan, my team has produced an assessment of the need for residential dwellings in Maidstone Borough, and likewise it's done the same for employment. It has to do, it's good practice, it's pointed out in the NPPF and the PPG. So, in a nutshell, what we have done is assess the need for employment floor space in Maidstone Borough up until the year 2031. The site which we are discussing tonight is by far the largest B-class employment site. So, again, rather simplistically, we are saying that the vast majority of our employment need in Maidstone Borough will be accommodated at this site. Yes, we fully accept there's constraints in terms of proximity to the North Downs escarpment and its open countryside. That said, it's highly accessible, being next door to a motorway junction. Sites have to be attractive to the employment market. So, with that need, we put forward an allocation with a very detailed policy, and indeed that policy, amongst many others, was agreed at full council. Following full council, I was given the mandate by full council to defend that appeal at the public examination, which I believe I have done so. The inspector went through in detail the points raised and other points as well. Obviously, in front of the inspector was the point that I just mentioned, that full council had agreed the local plan, certainly with respect to this site, but at the same time was fully cognizant of the fact that planning committee had refused an outline application with no detail whatsoever included apart from access. So through the examination, the inspector asked many questions around the duty to cooperate, and the duty to cooperate is looking to work with neighbouring authorities in terms of joint planning. Whether or not we should take some of their employment or they should take some of our employment, same for housing, etc., etc. And the duty to cooperate is a legal duty. And indeed, what hasn't been mentioned in the interim findings of the inspector, to quote the inspector, Mr. Mellor, with regard to the duty to cooperate statement, I quote Mr. Mellor, he says in the interim findings, "It has therefore met the statutory duty set out in section 33A of the 2004 Act." So we've complied with this duty to cooperate. I don't understand the references to studies, to further studies. What I do remember is arguments being put forward to Mr. Mellor that there were sites outside of Maidstone Borough which were available to take Maidstone's employment need. Even though Maidstone Borough Council was saying that it could consume its employment needs within its administrative boundaries. And I'm not aware of any neighbouring districts saying we can take Maidstone's employment needs. But that was in front of Mr. Mellor. And as Mr. Tim said earlier, what Mr. Mellor did key into, both throughout the borough and particularly with regard to this site, because it's the largest employment allocation, is the need to supply office space. And the office space, in terms of the proposed modifications, has increased by 5,000 square metres up to 10,000 square metres with specific phasing, because Mr. Mellor highlighted the need to accommodate that office need. What Mr. Mellor also looked at in detail was there's obviously a link between Maidstone Borough Council and the neighbouring authorities in terms of, it's all one big jigsaw puzzle, in terms of the link between housing, employment and commuter patterns. So there was a bespoke hearing, in fact it was the last hearing in the examination on the 24th of January. And Mr. Mellor heard evidence from myself and my officers on the very point that objectors have raised. And as I've said at Planning Committee, the local plan process is an iterative process. I know that people attended the examination, and for instance with the Syngenta site, the mixed site, a mixed-use site down outside Yalding. Mr. Mellor clearly had doubts about the suitability of the site because of flooding. And we had a discussion about it, and he advised that that site was taken out because of the risk of flooding. Indeed, it was taken out, or we're proposing to take it out. More advanced than that, as I know other members will be fully aware of this, yes, in terms of the interim findings, it's not 100% success. The inspector has looked again at 2 sites along Borton Lane. He'd heard evidence about issues with regard to congestion and highway safety, and advised that we take out those 2 housing sites along Borton Lane, and that's indeed what we did. In my opinion, Mr. Mellor made it very clear when there was issues. He highlighted them, both in this chamber, and he's followed that up by doing that in his interim findings. And actually, he's done more than that on certain sites. He's continued right into certain organisations following the publication of these interim findings. And I would just remind councillors that this is an outline application. So we're very much dealing with a principle of development. As Mr. Tim said, the control of what the buildings look like, the amount of floor space, etc., will be dealt with most probably through planning committee in the fullness of time. Thank you.
I'm sorry, I can't do that, but thank you.
Councillor, sorry, could I just interrupt there? Perhaps I could help and give a bit of advice. You are in a committee situation, Councillor Sams, so if you would like to open it up perhaps to some limited comments from the floor, then that's entirely within your gift, if you think that would be helpful.
Thank you. Okay. Yep. If you're...
Excuse me, this is unrehearsed. And the only reason I put my hand up, because I used to be very well behaved in class, was because I was party to... Is it okay, Rob? I was part of the coordinating team, and I could bore you with all the participants. And we attended so many days of the examination. But Mr. Jarman said that there was, and there indeed was, a session on the 24th of January, and that was in the context of ED 118, which was a report put together by Maidstone Borough Council at the inspector's request. But subsequent to that, the inspector asked for comments by, and this is where I may be proven wrong, February the 10th sticks in my mind. We were asked to put comments in, and several parties did. And we actually, I think, pulled apart most of the contention that the need for jobs within the borough needed to be restricted to the borough. And word of mouth, I've spoken to a Tunbridge and Malling borough councillor, and he believes that the duty to cooperate was exercised so superficially that it was more or less negligible, but agreed the duty to cooperate is not a duty to agree. So why the focus on this site? I'm pleased the coordinating team does not get into individual sites. We've been exercised by the procedure here. The focus has come back, and we've asked ourselves why, when the inspectors clearly pointed to the wider economic area of 5 neighbouring authorities plus Maidstone. And the inspector's report is due in a month or two. How he will absorb all the material he requested, I'm going to say February the 10th, but I may well be wrong. How he's going to take that, I don't know. But please, what you heard, Mr. Jarman was doing a good job from officer's point of view, but there is another side to that. And if this committee, if you were to defer and you want more information to back up what I've said straight off the top of the head, we will provide it. But you did not hear, I'm going to say, a balanced view on employment, and we cannot put thoughts into the inspector's mind. He is clearly uncomfortable, therefore wider economic area, therefore submissions please by February the 10th. So please, it is not assumed what the inspector will come out with. Sorry to interrupt. Thank you.
Thank you very much. That's no problem. And I think, obviously, there's been a lot of points made, and I would like to thank all the speakers for the way that they have presented those points and the way that they have kept time and been very clear about what they're saying. Councillor Garland would like to ask a question. No? Or make a statement.
Thank you, Chairman, for your allowing me. I'll be brief. Much has been made about democracy this evening. I understand the points have been made, but it was quite clear, and Mr Jarman is absolutely right, that a full council decision was made regarding the local plan. The local plan included Woodcock Farm. So I would argue that full council, being the full membership of this council, has a stronger weight than the planning committee, due respect to the planning committee. Secondly, Junction 8 development has been around for a long, long time. Kig was absolutely a monstrosity which was destroyed and it would never come back again. What is being proposed is an outline application only. Whether members or members of the public agree with the local plan, there are many differing views. The fact remains that Woodcock Farm, or that designation, is in there. I believe that officers are absolutely right in warning, in their professional judgment, members that they are likely to lose at appeal. My understanding is we will lose at appeal and therefore risk £400,000, maybe more, defending something that we cannot defend. It is already in the local plan, and members of the public have made the point that the borough local plan of 2000 is stronger. It is not. The inspector has actually looked at our draft local plan. We are all well aware of what that inspector has said. Bar 900-odd houses, he has generally found it is in the right direction. Therefore, the local plan that is emerging has more weight than the borough local plan of 2000. So a sense of reality needs to be around here rather than a sense of hyperbole and rhetoric. It is my strong view that if we proceed with the decision to continue to defend what is something that is merely an outline application, then we will lose. All the evidence points that way. It's my view. I may be a lone voice in here, and quite frankly, I don't care if I'm putting my head above the parapet. I have nothing to gain by doing so. But it is my view that it would be completely wrong to defend what is now increasingly likely indefensible. And as the officers have said, any application that comes forward in detail, that will be determined by the planning committee. This is merely an outline application. And the President is already set in the local plan, whether we like it or not, that's been agreed by full council.
Thank you. I'm not going to go through lots and lots of questions. I think we've had, well, question statements. We've had lots of. To the discussion with the members.
Madam Chairman, thank you. I would just like to ask, I'm looking at 5.3 and the grounds of our refusal, I would like an officer to explain to me why this was phrased in the way it was. The refusal was phrased in the way it was. Why weren't the grounds of the refusal stronger? I feel that this perhaps it wasn't. It could have been a little stronger than what it actually was. Thank you.
Yeah, the grounds of refusal were drafted on the basis of the discussion and debate at the Planning Committee. Officers have been criticised for the drafting, but officers cannot add to the discussion and debate, and that was considered to reflect what the reasons put forward for, which were that it was harmful to the landscape, harmful to the listed building, and it was based purely on policies in the 2000 local plan.
Thank you. So, can I just confirm that this was actually this was phrased by the councillors on the Planning Committee?
The reason for refusal was drafted in full by officers, but it was based on the reasons given at the Planning Committee.
Are you happy with that answer, Councillor Hinder? Yes.
Thank you. I'd just like to probably mention a couple of points I've heard this evening. One of the councillors on the other side, I think it was yourself, we mentioned about employment and not required over that area or something along that line. Well, the area I represent and the town, we need employment basically, and we need future employment. So I'd just like to pick up on that I think there's a very strong to keep Maidstone ticking, we need to keep the jobs here. But can I just pick up on one point about, when I put my glasses on, please, is it's been suggested that the site can be taken out of the local plan. Could you possibly tell me if that could happen, could you possibly tell me the risks of that would be, please?
As I said previously, it's by far our largest employment site. The simple answer is we would have to find another site or sites to compensate for that within our administrative boundaries. I say within our administrative boundaries because that's the case we put forward to the inspector at the examination.
I think it would be helpful if constitutional stuff is read out for the members so that we can have more information.
Sorry, Councillor Hinder raised a query earlier about how the wording of the refusal came about. Now, that was a decision against officer recommendation, and I don't know what was said at the committee itself, but this is the procedure that should be followed. If the Planning Committee makes a decision contrary to the officer's recommendations for refusal, a detailed minute of the Planning Committee reasons, which should be full, clear and convincing, should be made and a copy placed on the application file. The officer should also be given the opportunity to explain the implications of any decision contrary to his recommendations. The courts have expressed a view that such reasons should be clear and convincing. The personal circumstances of an applicant will rarely provide such grounds. More importantly, the wording of reasons for refusals should be clearly understood before the Planning Committee votes on a motion to refuse an application, rather than leaving the drafting to officers to do following the meeting, even if this requires the deferral of the application or a short adjournment in order to grant the wording. Sorry, to draft the wording. Sorry.
Thank you, Chairman. So can you just confirm then, so had we made this stronger, would this have made our case in defending it stronger? Basically, if we'd have put more in it, would it have strengthened our case?
Can you answer
I think the issue here is that the reason for refusal is a in-principle objection to employment floor space at Woodcock Farm against a policy allocation that in principle allows employment floor space. So the detail of what the harm and how much it was, for me, is not the main issue. That the main issue is an in principle objection with a allocation that in principle allowed or allocates the employment floor space there.
So can I ask whether the reasons for refusal, can they be added to by the council?
No, the council can't change the reasons it refused the planning application.
Councillor Mortimer.
Thank you. When I saw the written objection or for reasons for refusal on that actual when we had the minutes through, I actually thought to myself, because I went through the Bolton Lane appeal and I went through the SBS Toverall site appeal, I thought to myself, this is really weak, the wording in this, and I didn't think it was strong enough because I've looked at that strongly. But can I just ask regarding the actual 46,000 square feet on the site, can this change at any time, whether up or down?
Yes, it can. The outline application is up to that amount, as is the policy allocation at the site.
I'd just like to enlarge on that. So, for instance, in the reserved matters application, if details came in showing buildings of a certain size in certain locations, and they added up, just for argument's sake, to 40,000 square metres, they could easily be refused, because we would have the detail and we could say that building over there is too big, it's out of place, and the reserved matters application gets refused. So that's what I meant by having control.
Councillor Prendergast, do you want to say something?
I wouldn't mind some advice from my legal officer on whether the last comment from Councillor Mortimer was predetermined.
Can I just clarify, Councillor Prendergast, was that the comment about having seen the reasons for refusal?
And he thought they were extremely weak at the time.
That's not predetermination. He's entitled to have a view on something that he reads.
Thank you for that. Any other?
Yeah, thank you, Chairman. I just want to get it absolutely clear in my mind that the local plan went to full council with Woodcock Farm in it, and it was agreed by full council. If we were to defend this, and perhaps we won, it doesn't then necessarily mean that this will never be anything built on it, does it? That site is still in the local plan for development. Whether we agree to defend this or not, that site is still for development. That's what, please.
Yes is the answer. That's the case with the planning application process. Planning applications get submitted, they can be refused, they can go to appeal, and the appeal gets dismissed. Quite often, developers then will put in a modified application to address the concerns of the inspector, and so it goes on.
But can I ask, it wouldn't mean definitely that something would happen on that site if the appeal was upheld?
Yes, that would be. That it would always be dependent on a developer wishing to develop the land.
Thank you. I mean, people have mentioned how long this site's been around, and it's been around for some time. And I did some digging and it was in the core strategy in 2007. So this is where I'm struggling with this. We've got all this evidence and suddenly it comes to a grinding halt. 2011 core strategy identified Junction 8 motorway as a strategic location for employment. And then I go into July 2012. A Cabinet report assessed that Junction 8 would be the best location for critical mass employment. Where do I move down to next? Woodcock Farm site enables key mitigation measures to be incorporated within the design of the site. So, and it's all been supported through the democratic process with a Cabinet member at the time supporting it and signing it off, going to a particular committee for scrutiny, and now we've got the committee system where recently we've had the SPST approving items. So it's been signed off by various administrations over that particular time. So we've heard a lot about democracy tonight, but I'm really struggling with where we are at the moment here. And I've tried to keep an open mind all the way through about this, because I know it's contentious. I've had issues with sites. I know it's not the same thing, but over in the Lewes Valley, where we've lost Postley Road, Cripple Street, etc., to overwhelming impact on the Lewes Valley, which we were hoping to save, and that's all gone to pot now. So what I'm trying to say, what I'd like to know is that the situation where we are, what I'm saying is the history behind this, it is very, very indefensible. If this is brought out at the appeal, the amount of documents that there are and evidence that's been up to this, I'm really struggling to do anything with this at the moment. So.
Thank you, Councillor Moore. Can I go to Councillor Clark, who's got his hand up? Thank you. If it's going to help members, which I'm sure it will.
Thank you, Chairman. I wanted to bring something to the table. I wasn't planning to speak tonight, but there was some discussion about what happened at the Planning Committee. I was at that Planning Committee, and I will say that that was very much a split decision. This was not the whole of the Planning Committee saying that this site should be rejected. It was very much a split decision, and I would say that those that felt that on balance, don't get me wrong, I'm not saying that there isn't harm with this development. We all, within planning, we have to weigh up what comes to us in the officer's report and what is said on the night. And we look at the balancing act, and we look at grounds for refusal and how strong they may be in the balance mix if it were to go to appeal. My personal feeling, with everything considered and the fact that this is an allocated site, was that this planning application should have went forward. Now, it was a split decision, and for want of a better word, there was almost a scramble to try to work out a reason for putting this through as a refusal. There wasn't a clear, this should be refused on this, this, and this. I think officers were very much involved in building that case for refusal, and certainly several members of that committee felt that the reasons for refusal were weak.
Thank you. I think Councillor Powell wants to say something.
Madam Chairman, I mean, like Councillor Clark, I wasn't going to speak tonight, but I've been sitting here certainly for the last half an hour after listening to some absolutely excellent speeches tonight as to the reasons why we should go ahead with the refusal of this site, only to have a lot of that good work, good research, good understanding and sound knowledge being dismissed. I've sat at 2 of these planning meetings, and those meetings were discussed for a long time, and we looked at every single issue. Basically, we're going over the planning application again, which we shouldn't do. Because there was one decision that we came to the last planning committee on, and that was what grounds do we turn this particular site down? We came up with grounds. That wasn't good enough in the officer's eyes, but we still come up with good grounds, and there's been even more good grounds given up tonight. So to be quite honest, I can't even see why we're actually sitting in here tonight, given the fact that you've been given that information. We're asking for your help. After all, you're going to be the ones that are actually going to stand up on our side at that particular appeal meeting, when it happens, we've given you, by a majority of 8 to 5, that's quite considerable in my mind, cross-party as well. We've actually given you the mandate to stand up for the people of Maidstone and for the people that have spoken against this tonight, and to actually do the job on our behalf. You've got that mandate. My suggestion is you finish the meeting now and you go and do what we say. Thank you.
We'll allow it's quite calm clapping. And Councillor Springett wants to say something very small.
Yeah, it's just a very quick point, please. I'm sorry, Councillor Garland said full council voted for the local plan, and we've been told that full council voted for the local plan. I accept that. That was a democratic decision, but 25% of full council voted against it. It was not a unanimous decision. 25% voted against it, and I just want that on record. Thank you.
Thank you, Councillor Springett. We're now going to come to some sort of closure on this meeting. Sorry. Councillor Mortimer.
Just to clarify something, if I may, if somebody could answer it for me. I've heard about that. Now, I know we work in a democratic system and it's the majority, but I've heard 2 numbers tonight. In the report, we've got the planning application was 7.6, but a lot of people in that area are quoting 8.5. So
I think there's obviously been 2 planning meetings, and I think there was a 7.6 and an 8.5. Is that
Yeah, I
correct?
think that's based on the original planning application last year was 7.6, and when it came back in April for the appeal, that was the 8.5.
Councillor
Thank you,
Hinder.
Chairman. I'm struggling, to be honest, with this one, because we have to base it on the evidence that we can see before us. And looking at this, unless someone can come up with some better argument of what we can actually defend this on, because this site is a development site. Whether we refuse this or not, it's a development site. How do we defend that? How do we go along and defend something which will remain in the local plan? That's what I'm struggling with. Thank you.
Is there any more discussion? I'd like to say a few words. Obviously, we've been bombarded with lots of, information from all sides, and we've heard that the Planning Committee has agreed to refuse this on 2 occasions, and we've also heard that it's in the local plan, etc., etc. And it's obviously our role is to decide whether we as a council are going to continue to support the refusal and go to the appeal and defend the appeal or not. And I've been involved in politics, as people know, for a very long time, and often you're in the majority and a lot of the time you're in the minority. And we have to do the best with whatever the result is. And it's a bit like Brexit, I suppose. We can say, well, this is what's happened. We've had a referendum. It's a democratic referendum. You either agree with it or you don't, but you have to get on with it. You can also say that the reasons for that vote maybe weren't quite honest sometimes, or quite correct, or you were misinformed, but you've still got a result that has to be stood by. And my feeling is, and I'd like to make the recommendation, of a vote, is that I believe that we have a planning committee that has voted in a certain way. It has been told what the implications are. It has been told on the legal information by Estelle Cunningham, and they have taken that all into consideration. They are trained members. They have been in lots of planning meetings and they know the procedure. And I think whether you agree with what they said or you don't agree, that is the democratic decision. And I believe that we should vote to uphold that democratic decision. And I would like to put that forward, that we vote to continue to defend with all these other people that will put that strongly.
So the best way to do is to say that you're voting against the recommendation that's been put forward.
Yes. So what I'm suggesting to members, okay.
So I think what's being put is to vote against the agreement that the sole reason for refusal recorded in the Council's decision notice should not be defended on appeal.
Excuse me, correction. Point of order.
We're looking at the recommendation that is before the committee on the papers.
Councillor Moulton.
Do you want to read it out?
I'm sorry, I've sort of lost my thread. Been sitting there since upper six. I don't understand where we are at the moment. I didn't understand what we're voting. If we're going to vote now, I'm not sure where we are. Can we just vote on the as per the papers and recommendation one?
So what we need is...
Right, so there's going to be two parts to this.
Yes.
The first part will be to vote on the recommendation here, and then if that falls, then to vote on what you propose. Yeah.
Right, so we're voting on recommendation one to agree, whether we're agreeing it.
To agree that it should not be defended. Well, then yes, and then we'll be saying it would be that you will not be defending that you will. It's a double negative here, so you'll have to get this a bit of tongue twister. So
we're voting to either agree or disagree with the recommendation.
So it'll be either to agree or disagree, and then if it is to disagree, then you go to yours. Yes.
Okay. Right, it's very confusing, members.
Right, it's kind of like almost like a double negative. So we'll put the recommendation that is on the papers to you, and then you vote accordingly. You're either going to agree with it or you're going to disagree with it. If you then disagree with it, we then go to the next element of it, which is what the chair lady has put forward. Yeah? Is that understood? Okay.
Sorry, I just got to get this right. We're going to vote on recommendation one, and recommendation will go whatever we decide to that. Recommendation one. So we'll be voting either for it or against it, or abstaining. Abstaining. Yeah, that's what you're saying. Okay.
The recommendation
I'm
that
looking
you're
at page 5,
voting
that's what
on
I'm saying.
is to not...
The recommendation is to agree that this. The recommendation is to agree that the sole reason for the refusal recorded in the Council's decision notice should not be defended.
Councillor Hinder, are you clear on what you're voting on? Because it is very confusing, double negatives. Okay. Can I take a vote then on whether you are agreeing to the recommendation 1 or whether you're voting against. Those in favour? Those against? Okay. Then I'd like to put forward the recommendation that I made, that we agree that we will defend the appeal and we will support the others. Hang on a second, we haven't had a vote yet. Can I ask for all those in favour of what... Yes, sorry. That we agree that the sole reason for refusal recorded at the Council's decision notice should be defended on appeal. Okay. All those in favour of doing that? All those against? Thank you, members.
And then say, now you've got to repeat to say that the Council will defend.
Yep. So what's been agreed is that the Council will defend the appeal.
Sorry? We just need to deal with recommendation.
Can we just deal with recommendation 3 now?
Richard will.
Which Richard will go over.
As I explained earlier, recommendation 3 was a scenario whereby the applicant proposes to amend his proposal as the council has decided to defend its grounds and in effect is objecting to any development there. That recommendation falls away. It's not relevant anymore. Okay.
Thank you, Mr. Timms. Thank you, members. Thank you, members of the public. I close the meeting. Thank you.